Hello again, everybody. This is Attorney Craig, and this is One Lawyer's Opinion. And today we're going to touch on the story of Bobby Flay and his divorce with Stephanie March. Bobby has filed for divorce after an approximately 10.5-year marriage, filed against March and within the last few weeks. And what seems to be, or will be, the bone of contention in the matter will be the prenuptial agreement. And Stephanie March believes that it's unfair. Her attorney has come out and stated that it is unfair. And the question is, was the prenup unfair at the time of its signing? But perhaps a prenup can become, quote, unfair as time passes on. We'll see how this plays out in the court. But what's interesting is how Ms. March, or her attorney, is coming out and saying, Ms. March had contributed a lot to Bobby Flay's career, to his businesses, to his restaurants, that she was involved with the decor in the restaurants, and that she was a taster for Bobby Flay's recipes, his award-winning recipes. And I believe that this is what she's going to push to show that the prenup was unfair, that it does not reflect the contribution that she has made over the term of the marriage to Bobby Flay's wealth. But it is a very difficult thing to overturn in the courts, and bottom line is a prenup has to be fair. Although it might seem fair at the time of signing, perhaps if there was a lot of contribution by one spouse to the other, and the other spouse realized an increase in wealth because of those efforts, perhaps the court will step back and say, well, what's fair now? Perhaps. But also, if there was not a full disclosure of assets, that would be another way to overturn a prenuptial. That would be perhaps considered fraud. Whether or not both parties had separate counsel, if one party has counsel, the other doesn't, then you can see the courts might look more favorably upon the person who did not have separate counsel, as far as whether that person fully understood the significance of the legal impact of signing a prenup. Timing can be an issue. I don't know too much about the timing in this case, but if there's a timing very close to the marriage, oftentimes one spouse is under duress after all sorts of commitments have been made, wedding commitments, whatnot, and one spouse may be unduly burdened or unduly pressured into signing a prenup once a lot of arrangements have been made for the wedding. I could see that as being a possible factor. If there was anything in the prenup that was against public policy, we don't see any of that at this time. And that the person who wants to undo the prenup has to show some significant harm. I suppose if this prenup was allowed to remain in legal effect. So what's interesting is Bobby Flay is worth reportedly approximately $20 million at this time. Not a huge amount when we're talking about high-profile entertainers, um, they married in 2005, and at that time, Bobby was already doing television appearances, and he actually opened a restaurant in Caesar's Palace in Las Vegas that year, and I believe he had already been partners in earlier restaurants, other restaurants. So Bobby was already kind of big in 2005 at the beginning of the marriage. So you could anticipate Bobby's wealth increasing over the years because he was already kind of getting big at that time. And so does the $5,000 a month maintenance and the $1,000 lump sum, does that contemplate even, you know, does it contemplate that Bobby will be worth more later, and that the parties consider, even though there was an increase in wealth likely for Bobby Flay to such an extent as to $20 million, did they contemplate that that was a fair amount at the time in light of that potential earnings? I think that's one thing the court might look at, that it was no surprise that Bobby Flay would be worth $20 million at this time. No surprise in 2005. So we have another situation where Stephanie March's attorney, Nancy Chimtob, she's the same attorney who successfully overturned a prenup in New York. That's where this divorce is filed. She did this in New York and in 2013, and it's very difficult to get a prenup thrown out, but this lady was able to, and it was based on an oral promise by the rich millionaire to the wife that once they had kids, then he would tear up the prenup. And he was opposing that, and she was alleging that he made that oral promise. And what's interesting is that the court was allowing what they call extrinsic evidence or parole evidence, evidence outside of the four corners of the prenuptial agreement, to void the prenuptial agreement. It basically came down to a he said, she said, but what's interesting is that prenup, a good prenup, will not allow any terms to come in outside of the document. I suppose fraud can pierce through that, so there you have a New York court in 2013 throwing out a prenup done by the same attorney that is now representing Stephanie March. So I believe that Attorney Chimtob is emboldened by that prior court decision. That was an appellate court decision. And so it appears that she's quite confident that this, again in this filing, the court might look at factors extrinsic to the four corners of the document to determine whether the prenup was fair, whether it should be voided, and I think the bottom line is going to be, in this case with Bobby Flay, was the prenuptial agreement fair? And as far as my take on it, if Stephanie March can show that she really did make a contribution to Bobby Flay's business, and there was an increase in wealth realized to Bobby because of those efforts, I believe that she might get relief from the court and get an upward adjustment on the amount of money she's going to get under this prenuptial agreement. However, if the court looks at this in a strict sense, and if the court believes that the parties contemplated Bobby's wealth would increase, notwithstanding just the $5,000 a month and a $1 million lump sum, in light of that possibility, was adequate in 2005, and if Stephanie March did not play a significant role into the advancement of Bobby Flay's career or his estate or his earnings, then she might have a problem. But I believe in this case that there's going to be a tendency for Stephanie March to be able to convince the court that the terms now are unfair. At the time, in 2005, it was fair at that time, but because Ms. March put in her efforts into furthering Bobby Flay's career, that it would be unfair for her not to be compensated in some way, perhaps on a similar percentage as to what the $100 or what the $1 million lump sum would represent, some ratio, some percentage in 2005, and what number would represent the same ratio or percentage at this time. That may be where the court would go on finding a value on what Ms. March should be entitled to here. So basically, I think it comes down to what the court believes is fair, and that it looks like this is an agreement that could be opened up simply because the court back in 2013 opened up or voided the prenup based on evidence outside of the four corners of the document. So anyway, that's one lawyer's opinion. What's yours? Get money, 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 get money.